everybody if I let you out early. Hey, Bill Gross here, the LAProbateExpert.com, real estate broker in Los Angeles, California. And we do our probateweekly.com Zoom call every week, Thursday at 4 o'clock here. We also broadcast it live to, we also, we also broadcast it live onto YouTube. And so if you miss it, no, go out via email if you register through Eventbrite. If you're in the meetup group, you need to register through Eventbrite, so we have your contact info. We do that for security to keep out the nefarious parties. We let in nefarious attorneys, but otherwise we don't let nefarious people in on the call. And we do this every week. Normally I do a content piece. If you go to the YouTube channel, I've recorded 2 different pieces that I think kind of summarize my thesis on probate. One is 11 ways to make money as a real estate agent or salesperson in probate real estate. The companies that sell the data or the coaching really sell you on 2 options. You can market to the petitioners, you can market to the attorneys, and I've identified, I think, 9 other opportunities that I think if you work them as well, will make you better at those 2 as well. And then second, I do 11 different ways you can make money in probate besides real estate sales, lending money and flipping properties and things like that. That's in the YouTube channel. And then each week, I try to cover one of those topics. Last week, we did probate leads marketing to attorneys. And so next week, we'll do number 4 or 5, depending on how the week works out. But rather than marketing to attorneys this week, we're very privileged to have an attorney that I kind of spied out myself. I grew up in Orange County. So when I say behind the orange curtain, I say that with affection. But you know, I do try to research the marketplace overall. I do watch other people's YouTubes and their Eventbrites and such. And I saw on one of the calls an attorney who wasn't just obviously knowledgeable, but I believe also comes from the right place. I think the one challenge for us as professionals is if we focus just on the commission or focus just on the legal fee for an attorney, this business is a grind. And you can make money at it, but it will never make you happy. I think if you approach this as looking for people's problems and then try to solve them, this is a great opportunity in real estate as well as law. Shadi was going to be on last week, and walked to her office, walked a prospect, a customer, and the story she'll tell us the details on. She was apologetic for missing our call last week for that reason. I said, no, Shadi, that's why I picked you to do this call, because you come from the right place. I think it's really important not just to have an attorney. There's attorneys like real estate agents. There's good ones and bad ones. But I asked her on here because I think she really is, and having seen her website and her background, I think she really is a really special person. So Shadi Shaffer, welcome to Probate Weekly. Thank you for joining us.
Hi, Bill. Thank you so much. Hi, everyone. So nice to be here. It's really a privilege. I think it's just kind of nice just to give you a little bit of background. And when I talk about background, I'm not talking about education and whatnot, not that that's not important, but you know, I'm the first in my family to go to college, first to go to grad school. My dad's a contractor and my mom's a beautician, but what they are both entrepreneurs. And so that kind of parlayed into my life here. I will share that out the door, first of all, when I was in law school, I thought, what am I doing here with these people? This is so weird. And then in my first year of practice, I was in the litigation world. And I was actually really blessed to learn early on, I do not want to do this work. It's people fighting, and I didn't feel like anyone really cared. Not attorneys out there that don't care, so please don't take this the wrong way. But I just wanted to be in a proactive place where we're protecting and helping clients and being, you know, more helpful than reactive, if you will. So enter in estate planning. And I know for you realtors, there's a lot of hot topics. I really want to allow you guys some time at the end to ask some questions. Of course, some questions might be a little detailed, or I might need some more information, so I won't be able to answer all the questions, and some of it I'll have to follow up with you guys on. But you know, you guys are huge. I mean, your role for every American citizen is ginormous, because you are helping them with the biggest asset purchase of their lives. And I know for some of you, you're also helping individuals and business owners build their portfolio. So, you know, the role of the realtor is a very, very crucial one. And I personally feel one of the ways you guys could set yourselves apart from the rest of the crowd, like I'm sure you do just by being on this forum right here, is really being educated in the real estate part and on the title part. And in California, it's a big deal how you hold title to real estate. So in short, I just want to share with you guys, first of all, I've been doing this for 19 years. I'm going into my 20th year soon. And I've had my firm in Irvine for 16, 17 years. I'm starting to lose a little bit of track of that. And my whole focus has solely been in estate planning. So really early on, I got into the probate and estate planning world when younglings were not doing it. You know, I've been told in probate court, are you the clerk? Are you the paralegal? Are you the court reporter? I'm like, no, I'm the attorney. So it's kind of nice to be on the other side of the fence now. But anyhow, probate in California is very different than the rest of the nation. So that's the first place where I want to start off on. I'm always embarrassed to share this, but we're actually the worst state to go through probate court. So what I mean by that is California has the most strict probate rules and death rules. So when you're an individual and you die in a certain state, California is not the one you want to die in. And to keep it really simple, if you're anyone with any assets, you really need a trust, not a will. So you have to be really careful when you're hearing these things, because if you're talking to your best friend or your partner that's a realtor in New York, their probate rules are night and day different than in California. So every state has their own set of rules. So the first thing I just want to start by sharing is probate in California has this sort of threshold. In California, if you die and you have any assets over $166,000, and there's not some instructions on where this money is supposed to go to at your death, it's going to trigger probate. Okay. So, and typically real estate always falls under that. So my elevator speech is, if you own a business, if you have any real estate, and if you have any money over $166,000, then you need a trust. Okay. So that's kind of my fast elevator speech. Now, I said that, but I also want to share one other thing. I could be talking to a single mom who has life insurance for a 5-year-old son. Does she own real estate? No. Does she own money over $166,000? No. Does she have a business? No. But she still needs a trust, actually, because if she worked hard to build this life insurance policy and she puts little Johnny on there as a beneficiary, and something, God forbid, happens to her when he's 10, Johnny's not getting the money till he's 18. And now you've got a lot of legal issues as who accesses the life insurance. So I want to focus on real estate because, you know, you guys are realtors. And someone today said, did you know that there's more realtors than real estate all throughout the United States? And I thought, oh my gosh, that's crazy. So the good news is I think being an educated realtor is huge. One of the things I wanted to start out by explaining is title of real estate. You guys, many of you are familiar with tenants in common or joint tenants with right of survivorship. That is one way to bypass a trust. However, it's not the best way to do things. So if you're talking to an investor who's investing with his sister or his friend, they really don't want to hold title to that property as joint tenants, because their intention isn't that if one partner dies, the other partner gets all the real estate, right? The intention is if I die and I've been working all these years, I want my family or my beneficiaries to get the 50% of the real estate portfolio I'm building with this partner. Okay. Today, in today's world, everyone's not just necessarily married. Some people are married, they have mixed children. It doesn't necessarily mean that if I'm in my second marriage, I want my spouse to get half my real estate. I might want my spouse to live in it for the rest of his life. And then at the end of his life, it gets divided half to my kids and half to his kids. Same holds true for couples. Same-sex couples. You know, there's a lot of people that are not legally married and they have real estate together. So as a realtor, one of the ways you could set yourself apart is by really understanding how the law works. Just enough. You don't have to know a lot, but I always say just enough to be dangerous, and at least issue spot or say, well, hey, John, hey, Sarah, you know, this is what I understood. I don't really know all the moving parts, but you really should talk to a trust attorney. And I want to share my biggest passion in estate planning. I mean, don't get me wrong. We all are here to make money, right? It pays the bills. But my true happiness is knowing, you know, if someone says to me, hey, Shadi, I heard you talk 3 years ago, and so it pushed me to go get my family's estate plan in place. Stuff like that. You know, I'm kind of a trust nerd, and I love hearing that. So I always tell people, even people that call my own office, you don't have to hire me, but you do need to get this done. And by the way, attorneys make 10 times the money when a property goes through probate. So I always turn blue in my face telling people why they should spend $2,000, $3,000, $4,000 with my firm to do a very comprehensive trust plan, when I know I could just make 10 times the money. So there are a lot of people out there that will sell or do just a simple will for someone. And either they've educated the person and the person doesn't care, like they don't want to spend a couple of $1,000s, or they don't understand and they just do the will. But what happens is they do the will and then they pass, and then the girl or guy's, attorney's name is on the document of the will. And then they call them up and say, hey, they're telling me I need to probate my mom's house. And the attorney's like, yes, mom wouldn't pay me the extra $2,000, $3,000, but now you're going to pay me $31,000. And it's literally that expensive. So let me actually explain one thing, because for realtors, this is something you guys really, I feel you should know. If someone dies in California and there's a property, let's just say I died and I own a property, okay? And it's in my name. It's under Shadi Shaffer, a single woman, okay? The probate fees on that home is based on the market value. So, okay, so I could owe the bank at time of my death $800,000, right? There could be an $800,000 mortgage loan on that property. So what's my equity? $200,000, right? But the probate court is going to base the value of the legal fees and the probate fees on the market value. Why? Well, it's the liability of the asset you're dealing with. So they're going to base it on, and let's say in the marketplace, my house could sell for $1 million, okay? So the probate fees on just $1 million asset, hold your pants or your skirts or whatever you're wearing, $31,000. When I tell that to people, they're always astonished. And I'll be honest with you, I was practicing for about 5 years. And when I got my first case like that, I was like, there's got to be some, I was like, wait a minute, $31,000, that's the fee? And the entry fee to probate in California is $3,000. Now, I just want you guys to understand, I'm just talking general numbers. It could be $2,500 or $3,200, but I'm going to just average this stuff. Across the board, the entry fee in California, let's make the reference to Disneyland. Expensive to get in, even more expensive once you're in, right? You go anywhere in Disneyland inside and you're like, holy cow. It's the same analogy with probate court. I have to ask for clients to give us a $3,000 retainer, and that's just for the cost and fees. Not a penny of that goes into our pocket. And by the way, this is kind of the standard practice across the board. So it's not like you're going to run around trying to interview attorneys thinking one person's going to charge you less, because it's set by the court per the code. Okay, so they just look up the address. They don't care what the debt is on there. It's $1 million. That's a 30. So now the attorney makes $31,000 on the $1 million property value. Now, and what's worse is in probate, that's going to take 1.5 years. So right now our probates are kind of going between 1.5 years to 2 years. That's just crazy. I think the quickest probate in the history of California was 9 months. Those days are over. Now it's like 1 year, 2 months, 1 year, 4 or 5 months. And then with COVID, some of them have been 2 years. My longest probate, one of my cases was 4 years long. That was a unique case, but still, it was a 4-year case. Here's the other crazy part, as if that wasn't already crazy. You're already out the door $3,000, then you're going to pay based on the market value of the assets. And by the way, most people don't die just with a house, right? They die with bank accounts, a car, all that stuff gets thrown in. With the exception of if I die and my bank account says my brother, sister, mother, whoever is the beneficiary, they get that account. But anything that's not designated will go through probate. My car will go through probate, things of that nature. Here's what's even crazier. When a person dies, the attorney doesn't do it all, right? There's someone in the family that's coming forward and saying, hey, Bill, I need this help, or hey, Shadi, I need this help. I have to go through probate, okay? So that family member, if everybody agrees, that family member, let's say it's my son, my adult son. My adult son would hire the attorney, and now he's going to be the family member that will be in charge. Think of executor, those kinds of roles. So in probate court, typically they're called executor or administrator. Don't get caught into the labels, but it's basically the individual who's going to be the custodian or the person in charge of Shadi's estate because Shadi died. Okay. And there's all these rules that who could do it, who can't do it, who has priority. I won't get into that. But here's the crazy part, because now we're just talking, I want to always focus on time and money, right? Because those are our two biggest assets at the end of the day. Really, time now seems to be more of a bigger asset than even money, but we'll digress. That family member also gets compensated for his or her time because they're doing the work, right? Your brother has a full-time job doing his life, right? But now he's got to stop, go file the probate for his sister who died or parent that died. And after that whole 1.5 year process, working with the attorney in conjunction, right? Get approved as the court appointed administrator, list the property for sale, deal with Bill Gross's awesome realtors here. And then a year, and you can sell during probate, right? We could sell about 6 months later. Sometimes we get lucky and we could do it right at 4 months in this market. Never less time than that. And now the brother's going to get paid at the end of the year. Guess how much the brother gets? Bill, you're going to be shocked. I don't know if you know this.
No, I know this actually.
Tell me.
I know the same as the attorney fees.
Same
Limits the exact same.
Same as the attorney's fees.
Crazy.
That's crazy.
Yeah.
I mean, one of my clients once said, but you did all the work. I was like,
right.
Well, yeah, but you also did some stuff. You met with the realtor. You had to kind of.
There's work involved. Right? You go to the house and go through the things and the pictures, the photos, and
yeah. And so I sometimes tell parents, sometimes people go, I really don't care. So what? Let them get paid. I'm like, you need to care because the siblings are going to get in a fight with each other because the sibling that's not doing the work is going to say, that's not cool. Why do you get $31,000? And the brother initially will say, oh, I don't need the fee. I get this all the time, by the way. Oh, I'm not going to get paid, Shadi. I'm like, okay, well, we're not going to make any decisions right now. We're going to table that and come to it later. 1.5 years later, every time they're like, I need to get paid. That was a lot of work. I took time out personally from my work. And by the way, even if you say I don't want to get paid, a judge is still going to pay you. Because if they don't pay people, people aren't going to be doing this, like no one's going to come forward, right? If no one got compensated, why would they do it? Next thing you know, the courts are going to have to figure out a way to do it. So, the entry fee is $3,000 and then all the fees inside, it's just craziness. And another thing people don't realize is it's all public. When I say public, so James Candelfini, the Sopranos actor, right? Paul Walker, the young guy, Fast and Furious actor, blonde, died young in a car accident. These guys went through probate. Go, if you know how to do it, you could look it up online.
Prince, Michael Jackson.
Yeah, and it's all public. And when I say all of it's public, like literally there's a document that says, oh, he owned 5 cars and 10 watches and this is the value. And that's frightening because now right? Like Paul Walker was survived by a young daughter. She's still a minor. Everyone's going to know how much she gets now, right? And that's what's even worse is she's going to get the money at 18. So now you're like, here, young girl, here's $40 million. Good luck to you. And so a trust is an amazing thing because a trust is sort of like this little safety net, if you will, or a safety deposit box that has a book of instructions where you, the individual, can decide how I want things to be distributed. My trust today, I have 2 young boys. I started really late in life, and they're 8 and 4. And my trust says, okay, my boys get a money at, a third at 25, another third at 30, and another third at 35. What's more important is I know you guys work your butts off creating really strong relationships with your clients, but you'll lose that, I believe. Now, you could still lose it if it's under a trust. I'm not saying that, when your client dies, you might lose the relationship, but you'll have more control if the client has it in the trust and everything, because your client could actually say, and by the way, I want you to use Bill or Sandy or Chris or Suzanne to do the real estate portion sale. I actually, believe it or not, a lot of times when my clients come in, they go, well, can we put a note in there that I want them to use X realtor? I go, absolutely. Now, you have to be careful how you do that, right? Because something happens to that realtor and they're like, well, we're supposed to use, you have to watch the language, but we do it all the time. Absolutely. So, it's a serious thing. And, sometimes people want to cut corners. My favorite is the transfer on death deeds that California finally put into place. I think that was a year or two ago. COVID's got me a little off on my time schedule. Those are okay if it's a last minute deal. Yeah. I mean, I'm no one to prevent. Look, if a family called me once and they're like, he's dying, he's on his deathbed, it's my husband, I need a trust right now. I was like, it's in his name, the property? Yes. I honestly told that family, go do a transfer on death deed and then call me and I'll do your trust. And she was like, wow. I talked to someone else and they said, oh, this is how much it is. I go, no, I get it, but I'm worried you're going to run out of time. Now I could do a 48-hour trust, but she came to me, you got to take care of people, but that's a Band-Aid. Transfer on death deeds are not the way to go. And there's a lot of issues for that. You guys know, especially now with COVID, we're not all just dying. If we were just going to die, okay, yeah, maybe, and we're still going to have probate issues. But, a lot of us are getting sick, getting Alzheimer's, having a stroke. If I tell you the story of my own father-in-law, it's sad. It's crazy. He was in the middle of escrow, 62 years old, got into a car accident. Actually, it was an RV. He was retiring, bought the RV of his dreams in escrow, and he got in a tragic car accident, was in a coma for 4 months. My mother-in-law would not have been able to complete the purchase of that property but for the estate planning documents we had for her. That's huge. So even husband and wife, here's the thing people don't know. You could be married for 60 years with your spouse. You do not have the right to sign a legal document on behalf of your spouse. You also don't have the right to make health decisions, legal, financial decisions. And people are always shocked. Well, that's been my property for 6 years. What do you mean? I'm like, well, John, your wife now has a stroke and, escrow wants you to sign documents on her behalf. Do you have the documents, the financial power of attorney document in place? Do you have a trust in place, maybe where it's under the trust so you could sign as the trustee? And so these are the issues that people sometimes don't realize that is really, really important. I mean, I've had one colleague that was actually, it was a client, sorry, not a colleague. He calls me and he's a realtor and he's like, I'm in the middle of the deal. The husband got in an accident. And I'm like, Manny, I think I know what you're going to ask me. He's like, can the wife sign? I'm like, no, she can't. I know you're calling me because there's no estate plan or no power of attorney or anything, right? He goes, no, there's not. Is there anything that can be done? No. Is there, by the way, urgency? Can you go in urgently? I've got a case right now. My client wants me to make a petition for urgency because the real estate market is hot, because the realtor's like, you need to sell today versus 30 days from now or 40. The courts don't care. They're not going to do it unless the house is on fire and there's a 2-year-old in it. They're not going to, even then, like I've done a couple and they're like, not our problem. They should have planned ahead of time. Cause you understand if they say it's okay for me, for my client, then it's a domino effect. You did it for this guy, court, your honor. Why aren't you doing it for us? So that's kind of the gist of it. And I don't want to, babble too much, but I think the importance for realtors is really understanding how to take title. By the way, I don't think that you're the responsible party to tell them how to take title. They've got the options. And I know I've seen it. You decide, I've done transactions with my parents and I've seen them go, well, we can't tell you. And I don't blame them for saying that, but these are your options. But it's just good to be educated to say, well, have you, I noticed, you guys have had this property for a long time. Have you talked to anyone about a trust and whatnot? Bill, I'm going to stop there just to see if anyone has questions and, or if there's topics that someone wants to talk about, we can talk about. If you want me to continue more on the topic of probate and estate planning, I'm more than happy to do that. No problem.
Thank you. No, I have a few questions people have texted in on the YouTube and in the chat. I just want to say for the record that if you remember we spoke, what do we talk about? I said, Shadi, I'm going to introduce you and I know you're going to go on. I said, we'll be fine. No, it was perfect. Okay. It was great. Thank you so much. I knew you'd be perfect. This is great. Hey, if you guys like what Shadi's done so far, give me a thumbs up or give me a yes or something, or let's see something in the chat box, some feedback. I think she's been great. So one thing that you glossed over quickly, we talked about the fees, just to give people perspective, what's the cost to file the probate, the basic petition to administer an estate in Orange County? What's the filing fee for the county cost? And then what's the cost to publish? Let's say they're in Santa Ana. What's the cost to publish that, which is part of the required process? Just those basic costs that attorneys don't charge. What's the cost though?
No, we don't. We're not allowed to charge a penny for probate in the beginning. $480. I mean, it could be a little. It could have adjusted a little. Is the
file the form? Pay us $480. Thank you very much.
$480, and then about $900 and so is the publication.
$900 to publish a small classified in the back of a newspaper that nobody reads.
Yeah.
$900.
Yeah.
That tells you what probate's going to cost you right there. If you get those two, you're at $1,300. You even paid the attorney a penny.
Yeah.
You even started. You filed the form and published it. You even started it, basically. Yeah, good job.
And there's a bond too, by the way.
Oh, and the bond. Well, maybe you'll get a bond, but then you'll get the money. Okay, but the bond, what's the bond cost for $1 million?
Okay, so the bond's based on the value of the estate. So that's kind of a, I'm not sure.
$1 million estate?
On average, my clients are paying about $1,500, $1,600, $1,800.
Yeah.
And it's a yearly fee, right? So once you go into the second year, you're paying.
Yeah. So the probate goes a year and a day, you're going to pay a second. And people don't know that. And there's no way around it anyhow, by the way. You pay for the whole year on day one of the second year. So you're talking.
So you pay it all in full. And if that probate ends in month 3 of the second year, they'll give it back to you. The 7th, whatever.
Some will, I think, or you have to ask. It's not so simple.
No,
it's not getting debited your account the next day.
Sometimes you have to call and ask for it back.
Right.
Yeah.
So a question we got was, what happens if a trust is created in a different state and their residence is never updated? Is it still considered active or effective?
Yeah, I mean, a trust doesn't just. If I move out of California and I'm in Texas now, that trust is not void automatically. And if there's assets under it, it can still function. But, the legal system requires us to tell our clients, hey, Sarah and Bill, if you're moving to Texas, eventually you can't keep calling me. And my clients try to do that, which I love. And I'll talk to them, but I can't do any legal work for them because I'm not licensed in Texas. So what happens is the trust doesn't poof up in thin air here. What you do is when you go to Texas, and once you need to start changing things, they'll do a redo of that trust plan. They keep the same title and date, but they redo all the documents to now Texas law, and then you keep going on your way. So if you have assets held under the title of the trust, you don't retitle assets. That's a no-no. That's like malpractice. That's not a good thing to do. So that title stays the same, but you do eventually want to change. But, I have a client who's in actually Texas now for about 4 years. And she just, the other day, she's like, I didn't change it yet. And I'm like, well, it's still valid. When she bought her Texas property, she closed escrow into the name of that trust. You could do that. That's totally allowed.
Yeah. Okay. If someone goes to probate, can they sell the property before the case is heard? Well, I think the answer is, no, the judge has to give the authority to the estate. And then in LA, you got to get the actual document. That's a whole nother rigmarole in the LA court. In Orange County, after somebody gets authority, how long is it before they get the signed order by the judge?
Yeah, it's becoming a problem lately, Bill. I actually had a probate just today get approved, right? So my administrator's been approved, but the paperwork might not show up. The order saying, hey, John Smith is approved, might not come to me for 3 weeks. And there's nothing I could do to get it from the judge. You imagine these judges have like piles of documents that they have to put their ink on. And so it's just a process. It's a very tough thing. I do know, I'm going to speak very freely here. I do know people sometimes will go forward and list. It's almost impossible to actually officially close without that order. So you want to be very careful, especially in this market, because things are closing. Like that happened to me in one instance. And I thought, oh my gosh, we're going to get in trouble. The judge is going to like kill us, and because they were like literally closing escrow and they didn't have the order. And I was like, it was bad.
So the answer is you really can't. Do you in Orange County, do you prepare the order for the judge to sign, or do they
We
prepare
do.
it themselves? Okay.
No,
So you prepare it and they kick it back sometimes, you can correct it.
Yeah.
I have a friend who went to Riverside Court last week, and they actually, we call a minute order in LA, where the administrator kind of types up some notes.
Yes.
They actually, I think Riverside actually prepare the order, get to the judge, sign it, and my friend came home with a signed order that day. Like, what? You can do that?
Okay,
Life outside Los
I'm gonna take all the
Angeles.
Riverside cases now.
I'm telling you. That's
Yeah.
Yeah. A lot of positive feedback for future assets after trust is created. Not originally trust, you need a new trust.
Oh,
So
no.
you have a trust created. Can you buy a new house? Can you buy new bank assets? Can you buy new stocks, bonds, and such?
Yeah, that's a great question. No, just understand, when you create a trust, it'll last you like 20, 30, 40, 50 years. And all you're doing is think of it as like a bucket or a bowl. You're putting stuff in, you're taking stuff out, you're putting stuff in. You could do that all day long. You just need the guidance on how to do it properly. One of the reasons we set ourselves apart from a lot of other law firms is we're not like a transactional firm. Like, here's your trust, good luck to you, have a good life. My clients call me all the time. We had one call today, and he sold and he bought, and he needed a document so that he could send it to escrow to put his new property now into the trust. So you can buy and sell assets, putting it in and out of the trust all day long, including
Similar to corporation, right? You just title it properly,
Yep.
right?
Yeah.
I never get this question. I'm going to take it a little personal. HN should be doing more YouTube videos. So you have a fan here, Mark.
Oh, that's just.
Pedrosa.
I have actually a YouTube channel. It's called Asset Protection TV. And I apologize, Mark. I try really hard to keep it up to date. I have a lot of videos on there. My partner does too. We've gotten a lot of traction from it. And my goal for 2021 is more videos. I did some in 2020.
Nice.
I need to do more. I need to do more. Yeah.
I got a question. If 900,000 has a AS5 mortgage, still 30%. I'm not sure what he's asking there, but I can answer this. Bill, I'll answer your question. If you have a $900,000 property and it has an $875,000 mortgage on it, not only is a short sale for the commissions and closing costs, but there's no money there to pay the attorney's fees. So an attorney may or may not take the case, or the other costs of the matter. So that's a real problem. And we have from time to time short sales. I know you experienced, Shadi, tell us that short sales where there's not enough money, but the fees are charged at the same as the full asset, right?
Yeah, that's a dangerous one. I have to be honest, I got really hurt in the beginning, and I'm not, I had a very personal thing happen to me when I was 18, and an attorney liened my dad's property. So I shouldn't probably make this super known in public, but I don't go after clients for fees. I just say, you know what, it was a bad case. I'm going to move on with my life. It's easier for me to make new money than chase old money, or bad money, if you will. So I've had a couple of those. I have to tell you, I do watch my cases now that come through to make sure that doesn't happen to me. Here's the thing, just because there's not enough money in the real estate doesn't mean there's not other assets. So I do have one case where they're under on the property, but the family wants to keep the property. And I had to tell them, well, we need some reassurance that there's some money somewhere else where you're going to pay for the cost and fees. And they did. They paid it from other sources. But there are some estates that are just underwater. And I had one brother call me once, and he was like, look, my parents are under the water. My mom died years ago. My dad just died. What do? I don't care. I don't want it. It was a tough one, but I was like, you don't have to do it. Just, you could almost go to the lender and say, I'll sign whatever legal documents you want. Here you go. Deal with it. And sometimes the lenders will take it over, or a public administrator. The court, it still has to kind of go through probate, but they'll appoint like a public administrator if there's no one. There's always a backfall, if you will.
I'd say I've handled some of those cases where we find a paralegal who on the cheap will just do the paper. If it's just one property and the cheap, they'll do it. And that's another way out. There's enough money. But there has to be a reason for the estate to do it. There has to be some benefit to the estate. Otherwise, you can't just do the realtor's commission. It's got to be for the people, the estate, the court.
Yeah, and be careful because, I'm a straight shooter. Someone will call me and like, well, I don't want to pay you $4,000 to do my trust. Okay, here, go here, go here, go here. I'm not responsible for where you're going, but I'll tell people how to do it. I'll tell you, the do-it-yourselfers, the paralegals, I mean, unless they're really no probate, then great, because there's some amazing paralegals out there that know their stuff. But you have to be careful.
Yes.
We've seen some interesting things coming out of the probate court lately, and it's hard. My paralegal and I were like, what? We've been doing this for like 20 years almost. So, I mean, combined together, we've been doing it for 35. I have a probate case tomorrow morning and for LA court, actually. And it's everything, it says actually on the document, like everything's in, everything's good, but you still have to appear. And the judge wants a bond for some strange reason. I'm like, okay, so you just don't, lately it's just gotten even harder. I don't know why.
I'm going to be in court tomorrow. I'm representing an investor buying a property. Maybe I'll see you there. Let's talk afterwards. Maybe we'll catch up for a cup of coffee or something.
Okay.
A question, I know the answer, but I want to ask you a related question. Question from Rekha Kumar. Does all property need to be in the trust? The answer is no, it doesn't have to be, but maybe you can explain what a pour over will is and how that might protect somebody who forgets or might set up you can talk maybe a little bit about a Hegstead petition. What happens if assets are left out of the trust? Can they be in the trust?
Okay, so not all assets have to be in a trust. You just want to really understand what the intention is. So, for example, you can have a bank account and you could just decide that bank account is going to go to the surviving spouse, or you might have an account with $100,000 in it. That's really like your money that you hold for your parents. So you could designate whoever you want as the beneficiary. If you've got financial accounts with beneficiary designations, that actually supersedes a trust. So you want to be really careful, because sometimes people are like, oh, well, I have this much money. And then when you really dig deep, you're like, well, yeah, but you have these people as the beneficiary on this account. Well, yeah, no, it has to be those people. This money came from here, or this is my intention. So then you don't want to put it under the trust. So it's not as simple, people think it's not always as simple as it seems. Like, let me create a trust, let me put it all in there. You don't necessarily always want to do that. I personally, every attorney's different. I personally never suggest my clients to put their IRAs and 401ks under a trust. Beneficiary designated. You can't title it into the trust. There are trusts that you can create for the purposes of IRAs and 401ks, but typically we just guide clients on how to beneficiary designate that. So you could have your house be in a trust for your kids, but leave $100,000 account to your boyfriend or your maid or whoever. So you could carve, it's like think of it as a pie that you own, and you can carve it out. This goes in the trust, this doesn't go in the trust, and so on. Like, you don't go and I don't change the title to all my clients' cars and put it under their trust. But there's a document that I create that says, if I die, my brother could easily sign the DMV documents and paperwork and either transfer it to my son or daughter, or sell it, And those are issues. I mean, I get the ones that really kind of frustrate me are when they don't have a lot of assets, they have a car, there's a bank account, and there's no beneficiary and they don't know what to do. Those are really tough, because then it becomes cost benefit. Like, it's not even worth it for them to pay us to do it. So I'm like guiding them on the phone, trying to tell them what to do. And that actually is a more time zap than if they just hired us to do the work, but it doesn't make sense,
Mark asked, letters of administration or letters of testamentary? So I think we use.
Yeah. Okay. Let me explain one thing. Okay. If I die in California and I created a will, a valid will that is signed, notarized, dated, and witnessed by two people, I see these wills like, oh, my husband had this amazing will. And I read it and I'm like, well, it wasn't witnessed by two people over 18, or I got a will once that was notarized, signed and dated. That's not a valid will. So they don't care how pretty it looks. If it's not valid under the law, it's not valid. But if you have a valid will and you die, that's the difference between the two terminologies. Letters of administration is when I die with obviously no trust and no will. Letters testamentary is when I die and I have a will. What we do is we go, here, Your Honor, here's Shadi's will. This is who she wants to be in charge. This is who she wants to get her stuff. By the way, her will says no bond. Here you go. And if the judge wants, by the way, this is the judge's world, not ours, which sucks. Because trust me, the will could be perfect and the judge might go, well, you know what? I know Bill said he doesn't want you to be bonded, brother, but I want you to get bonded. And these are my reasons why. So, But that's the difference between the distinction for the two. When you have a will with a trust, that's where it's called pour over will. When you have no trust and a will alone, that's just a will. And the pour over will just says, hi, I'm here because I have certain legal significance, but go see my trust. Everything's pouring into my trust. When you've got the trust and will together, the trust is the big kahuna. The trust is the boss of it all. Let me tell you something. The trust is the best thing you'll ever get in this life in California, related on this subject. I'm very pro trust. I'm anti anything else. And like I said, I make way more money in probate than doing trust. But I want people, because it's private. A trust is a private document. All your affairs aren't going out in the public. So it's a huge distinction. Another thing a will does, a couple other things, but I don't want to get too much into the forest, is it talks about funeral arrangements, cremation, burial. Very important for people with grandchildren or minor children. Me as a parent with minor children, my will says, by the way, my children's guardians are this person and this person. That is huge. Just so you guys know, if I didn't have a trust, I'm going to just kind of break it down. A lot of people don't have estate plans, right? They don't even have powers of attorney, financial, durable power of attorney, and healthcare directives, right? If I go home tonight and get hit by a car and I'm in a coma, who can sign my checks? Who can keep on the lights of my business? Who can write my mortgage? Who's going to pay the mortgage, pay the utility, all that stuff, right? Who's going to make decisions for my health care? If I don't have those documents, guess what my family has to do? They have to go hire an attorney. Right there, you're already losing. I mean, I'm not trying to offend attorneys, but you're already like, your loved one's in the hospital. Now you got to call an attorney. Like, who wants to deal with that? And now the attorney is going to say, okay, Shadi, give me $10,000 because that's how much it costs to now go and file for a conservatorship. And now they're going to,
and then they're going to charge for guardianship for your kids.
Oh, that's the other thing. So then if I go on date night and my husband and I get in an accident, my parents who are taking care of my children right now always take care of them. The judge is going to be like, I don't care that you always take care of them. You need to be appointed as their guardian. You could be a crazy person. You could be an alcoholic, right? If Shadi and Luke decide who wants to be their guardian, well, we're not going to question that unless they give us reason to. But otherwise, if they didn't put the plan in place, now as the court, we have to protect everyone and oversee all these things. $10,000-$15,000 cost total for conservatorship court. Yeah. So I'm always like, why do you want to even go through that? I mean, if you think about it, a trust avoids conservatorship court, that's 10 to 15. An initial probate, that's $3,000 plus all the additional fees. If you have children, you're avoiding guardianship proceedings. There's so many moving parts to this that makes your life huge. I mean, Medi-Cal, you can have an aging spouse who needs to get on Medi-Cal, right? Or you could be a young person and get in a horrible accident and you need some serious rehab or treatment, and someone in your family needs to go to the government and say, hey, we need help. They're going to be like, well, who are you? So, it's not just about, real estate and money and things. This is like about our own desires of what we want for ourselves. And that is so, so, so important. And that is all a part of a comprehensive estate plan. So, when you go to an attorney to do a trust, all that should be included. Should never be, in my opinion, piecemeal, but everyone has a different approach, I suppose.
Is a minimum of 90 days to sell the house? I can answer. It could be less. You file, get a hearing date 30 days. You have letters of authority theoretically signed that day. You could be selling and closing in 40 days. It just never happens that way.
No, actually, if I may. So today's 5/20. My paralegal and I just filed a new probate for a 48-year-old woman who died. She owns a property with her brother, a third, and has a 16-year-old daughter. Talk about a hot mess. And I found that out, I think it was the day before my 47th birthday, and it was tough for me. It was just such a sad case. And we just filed the probate today. They gave us a hearing date of July 1st.
Oh, wow.
So I'm telling you guys, from the moment your client, it doesn't work that fast. And by the way, right now, what's happening that people don't realize is death certificates aren't coming quickly like they used to because of COVID. So now you can't do anything till you even get a death certificate. So delay, probate hearing delay, the person gets approved. They can't sell the house till they get the order, which is another delay. So when clients come to me and say, what's the soonest I could sell my dad's property? I'm like 4 to 6 months. Because if you don't set the expectation, they get kind of upset.
I will say in LA, the one thing that we're doing well is we have down the file to hearing date for appointment is about 30 days now. It was 90 and 120. I'm looking at the data right now. Things were filed today, got dates of June 22nd. So
awesome.
Yeah. Now everything else, Hegsted's is 6 months, but everything else that's different.
Yeah.
So the answer, Jamie, is it depends. And of course, that's to the hearing date. You have to get the order signed. You probably need a notice, a proposed action as well. But anyhow, that's the way it goes.
In my office, I always try to get my administrators or executors approved with what's called full authority. So always remember that word. You want full authority. Lately I'm seeing they're being a little bit strict. One of mine, I asked for full authority and judge said, no, I'm giving you limited. I got very lucky that one didn't have real estate. What that means is if you have full authority, you could just sell the property. You don't need court approval. If you have limited authority, you have to get court approval, and that's a whole other delay.
And that's rare in Orange County to get limited, but in LA, it's not uncommon. I mean, we do whatever reason the judges are a little stricter on the limited. And part of it is the way they present it. They'll say, oh, you can have no bond if you go limited authority and save money on the bond, or full authority, you get a bond. And now we say, get the bond, because the limited authority now requires the whole court process. You'll pay more in court fees and publication than the cost of the bond that you think you're saving. So,
yes. Yeah.
Okay. Question. Who's Shadi? She's a probate and estate planning attorney in Orange County. We'll get her contact info at the end. Who's Mark Pedroza? He's a real estate agent who comes on our call and is a participant. We appreciate his support. Are trusts effective? This is from Charmy. Are trusts effective for maintaining privacy?
Yes, very effective. Absolutely.
Yeah.
When you die, if you die in probate court, a creditor knows every penny of the money you have, and they, by the way, get paid 100% of their money. Yeah. When you die with the trust, your trustee and your family has more leveraging power, because now the only thing that's public is your real estate, assuming it's not in an entity or something. And so now you've got more leveraging power to say, hey, yes, my mom owed you $21,000 on this credit card, but we want to pay you $10,000. Will you take it? And trust me, they now, when you have a trust, if they want to go after you for the full amount, they have to actually sue. They have to actually go through a whole legal process. So now they have to spend a lot of money, right? They have to spend legal fees, right? So they're like, oh crap, I've got 21,000 this guy owes me. Do I want to spend 5 or 10,000 to get the 21, or do I want to just take the 7,000 or 10,000 they're offering me? In probate court, it's crazy. All the creditor has to do is file one document. I mean, there might be, if someone objects to the validity of the debt, of course, there's some more paperwork, but creditors love it when we don't have probate, because, when we have a probate, when we don't have a trust, because they're like, yay, they just opened a proceeding for me, a legal proceeding. Right. I don't have to pay all these other attorneys and legal costs. I'll just file the one page and I'm going to get every penny of my money. They don't care if our kids end up with $100.
The creditor can file a one document and basically get copied on everything for the rest of the probate. It's an amazing process.
Yeah.
How does a reverse mortgage work on a probate?
So it's the same. It's more or less the same. Reverse lenders that I've worked with, dealt with, sometimes they're very cautious about the trust. They need to see the trust language. Now they've gotten much more, they've become up to speed and savvier. So they are okay, as they should be, to put it in the trust. I will explain to you guys something though. Almost across the board, lenders will not finance under a revocable trust or any trust. They make you take it out of the trust. They'll do the financing funding, and then you put it back into the trust. So with reverse mortgages, that's tough, is that there's a time frame that you have where then they could just call the note and they can go through their own proceeding and process after the person dies. So there's some time sensitivities, like you have 9 months after the date of the person's death to pay them off. And then sometimes you can get an extension. So there's some time sensitivities, but it's the same process as with a regular forward mortgage.
As long as you're buying a whole property on the trust name, if you need to purchase, how it sell. trust, do you need anything when selling property? So kind of some questions as far as, so I would just say, Miguel, that's a long question with a lot of pieces. That's a question. The best source there would really be your title rep, because at the end of the day, Shadi could be right about the legal requirement not needing something, but if the title companies won't give title insurance, doesn't matter what the law says, the title companies sometimes are more conservative than the law and require things that legally aren't required. And they can say, well, if you don't like our requirement, then go to the title company, and they all kind of do the same thing. So the right person really to ask the questions as a real estate agent would be really your title rep, and they would go to their title officer to get those kind of technical details on what's required when selling.
Yeah, a certificate of trust is what is typically used. Miguel's asking the question that I actually just answered, I think, Bill. You still go forward with like the purchase. So you asked, how do you sell it if it's in a trust? You list it for sale. The listing agreement could either be the person, or it could be, the Shaffer family trust, right? Those are sort of technicalities that every escrow is a little bit different, but I just want to explain, a revocable trust is the person. It doesn't have a separate tax ID. It's my social. So it is me. It's the same entity. It's not like a corporation or like an irrevocable trust. I don't want to get into that stuff too much. Those have separate tax IDs. It's a separate entity. That's a whole separate thing. But typically, like I said, you could just purchase, when you're in escrow to purchase, sometimes they'll fund in my name personally, and then they go from my name, the person, into the trust. Every escrow does it a little bit different. Some are lazy and don't even want to do it, if you don't mind my saying.
So I'm going to stop here as far as questions. We have a million more questions. I don't know what we're going to do with all that. First thing I want to do is, the next thing I want to do though is ask if I have a question regarding preparing a trust, or I want to avoid probate, I have assets that the family take care of. What's the next process, Shadi, if I wanted to talk to you about helping me prepare for that eventuality? What would the next step be?
Just calling the office. I'll put my contact in a second in there, and I put my website.
I have that. I have a phone number, and I'll put that in your website and your YouTube channel as well. So if you want to see more, if you just didn't get a shot, I got to tell you, Shadi, it's amazing. We have 22 more questions. We're not going to get to, I don't think, today, because we're going to wrap up here. But I am putting in her information with her phone number and her website and her YouTube channel, which is something I checked out. I thought it was really helpful, and it's great. And definitely, we all should get more Shadi in our lives. I don't know what to say. We kind of wrap up. It was phenomenal. I appreciate you. I agree with you. I think that anybody who owns a property in Southern California should have a trust step. True or false? Absolutely.
Oh, true. 100. I know it's easy for me to say because that's what I do. Yes. I say this like, don't ever call me, but please have a trust. Literally, I mean this from the bottom of my heart. I'm telling you. I know of an attorney that'll do a will plan for you any day of the week and charge you $750, $950 because they know on the back end they're making $30-some thousand, and that is just not okay. I'm sorry, it's not okay.
So we got 20 questions I can't get to, but one of the questions is, can we have you back sometime? So Shadi, I'm definitely going to reach out. I really appreciate being with us today. I can't afford your hourly rate, I don't think, but I certainly.
No, I'm not one of those guys. I promise you.
Well, and if you have questions on family trusts and or estate planning issues, obviously probate litigation, give Shadi or team a call. And she's in Orange County, but she's in LA County regularly, in Riverside and Southern California. Her license is good throughout the state. So just, from the bottom of my heart, Shadi, I knew this would be fun. I really appreciate you making it 2 weeks ago. Thank you so much.
Oh, thank you. Sorry again about last week, Bill. Thank you guys. I'm always here to help answer any questions or at least refer you to someone. I have referral partners. You need someone in your town or city, I'm happy to refer out. Just that. I
got some questions about how to generate business of probate. I saw you in the chat box. I'll go ahead and reach out to you individually. On my YouTube channel, I talk a lot about how to get business, how to reach out to estates, how to reach out to attorneys, how to also find business through other marketing methods I think are important. I don't charge for it. I don't sell that. I'm just a real estate broker here in LA County, helping agents like you build your business and build your wealth. So again, thank you to everybody who participated. Mark, thank you for your special help, and a special Shadi. It was amazing. Thank you. If I could ever pay you back, and we'll have to do this again sometime.
You are
Okay.
so sweet, Bill. I
Thank
am
you.
so thankful just to be here and
Thanks.
educate all these wonderful people. So thank you
Thanks.
guys, really. I love doing this part.
Thanks.
It's just something I really like to do. So I appreciate
I knew it, by the way. I could tell the first time. I could, what am I going to say? Like you're all shy in the mirror. What am I going to do? No worry. I know what to do, Shadi. I'm going to introduce you. You'll take it from there. Not to worry. It was fantastic. Thank you so much.
Thank
Okay,
you,
buddy. Hey, Bill Gross. This is probateweekly.com. We do this every Thursday, 4:00 Pacific time. We also put it on YouTube. We send it out if you're registered in the Eventbrite. If we have your email, we'll send you a copy of this every week as well. Please like it if you like it. If you don't, put a comment in the YouTube or email back. We want to improve this. We want to get better hosts like this. Subscribe to the channel. The more people on it gives me more leverage to get good vendors and good partners and good people like Shadi. So thank you for all participating today. Have a powerful week, and we'll see you soon.